Please be seated. We're ready for argument in 23-329, Bertucci versus Watkins.
May it please the court, Mr. Fleckman will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, members of the court, may it please the court, for two key reasons, this court should partially reverse the Court of Appeals decision. First, the dissent is correct. Executor did not commit briefing error. Executor expressly invoked appellate jurisdiction in both of his capacities, individual and derivative. The claimant companies were identified in his notice of appeal. They were also identified in his docketing statement. The court identified them in the style of the case.
If that's correct, if you're right on that, then doesn't the rest of this just kind of go away?
It may indeed, because we did brief derivative claims. We briefed them on fiduciary duty starting at 59, page 59 of our appellate brief, the opening brief. We briefed them on damages because we said the infirmities of the report affected every single appellant. We briefed them on limitations because we said the companies were not alerted of the misconduct until 2014, when the particular event occurred that gave notice to the Bertucci family. And we briefed them on the dead man statute, which was specifically also briefed by our opponent on that issue of applicability to the derivative claims. So there are actually three statements by the Court of Appeals that I want to briefly address. One was that we had failed to appear in the derivative capacity and only appeared in the executor's capacity. But that's a contradiction in terms, because the executor's capacity essentially couples the two capacities of his father, the decedent, one of which was individual and the other was derivative. So he inhabited both roles in pursuing the case on behalf of his father's estate. Therefore, there were no distinct capacity outside of the role of the executor. The second thing that the Court of Appeals said was that we had failed to raise the issue of derivative claims with regard to breach of fiduciary duty. But as I just mentioned, on page 59 of our brief, and for about 10 pages thereafter, we briefed the question of fiduciary duty as to the companies, as did our opponent. And the third thing was that the majority concluded that we had not raised an issue specific to the derivative claims in our briefing. But for the reasons I mentioned a moment ago, we raised several of the issues, and not only were they specific to the question of derivative stand and the derivative claims, but in addition, we had raised issues that were overlapping between the individual claims and the derivative claims. And this court has held in the case of Lion Copolymer that where there are overlapping and concurrent claims, the court should be careful, the Court of Appeals should be careful not to infer briefing waiver. In fact, under 38.1F, the appellate rule requires that subsidiary issues fairly included in the statement of the issue are covered by that rule. And in your recent case, in the last term in Gill against Hill, you applied that principle in a case involving a tax sale, and a due process claim that had not perfectly been articulated, but was nevertheless included in that particular principle.
If we agree with you that you haven't forfeited or waived the derivative claims, what else do we need to address, and what else can we let the Court of Appeals deal with?
Well, I would suggest one thing on that. I can see that given the overlap in the rulings with regard to the individual claims that the Court of Appeals has addressed and the reversal of summary judgment on those, it may not be necessary to remand the case to the Court of Appeals. You may be able to render on briefing waiver and render on the overlapped derivative claims. So that, I leave that to the discretion of this court.
So
But it
one
is-
of those issues that the Court of Appeals reversed was, I believe, statute of limitations. And what role did Mr. Bertucci have in connection with the companies? He was a majority partner, majority owner, and then what other roles did he have?
Justice Bland, I'll kind of give you an overview of this. The two men had essentially agreed to a delegation of duties. One, my client, Mr. Bertucci, now deceased, agreed to fund the venture. Mr. Watkins agreed to be the operating manager and accounting manager for the venture. And that's where they began. They agreed that they would receive profits from the sale of property and from development fees, and those would be distributed to them, and they have prospered from those distributions mightily, both of the men. But what they did not agree to was to take more than $39,000 of compensation. And that was during a brief 6-month window of construction of one of the projects. After Mr. Bertucci died, or before, let me back up for a second. I'm addressing limitations. The reason we say that limitations has not run is because limitations under the discovery rule requires a determination, conclusive determination of the accrual date. And there is absolutely no accrual date. There was no alarm bell. There was no reason for suspicion between these two friends as to the integrity of Mr. Watkins until
So-
2014.
Right, so they rely on our Berry case and say Berry means that he was on inquiry notice because he was receiving information about the companies.
It cuts-
And that the misappropriation occurred, the alleged misappropriation occurred in the 2005 to 2007 timeframe, but suit wasn't brought until 2016. So even if there's not a fixed accrual date, if you back up from 2016 to 4 years earlier, is the idea that it was told for those 5 years?
The,
And how does that square with Berry?
well, first of all, let's look at the Berry circumstances. First, you had 15 years, a trustee of a trust that owned 98% of the ranch company. He knew that there had been a lease. He had access to the bank records. He had no basis to trust his brothers. They had had open hostility and adversity. The environment was not one that cultivated trust. And under those circumstances, given the fact that there was a lease, he knew there was a lease, there was a memorandum of lease, he just made no inquiry whatsoever. Contrast that with our situation. In our situation, contrary to what my colleague argues, Mr. Bertucci met frequently with his colleague and friend, Mr. Watkins. That doesn't show that he was informed This man was putting in millions of dollars into this venture. What that shows is that he continued to fund this venture up until 2011 without being informed fully of the defalcations by his partner. And that suggests there was a breach of the duty, the absolute duty of full and fair disclosure, which is a fiduciary duty that Mr. Watkins had. Now, the proof of that is that after Mr. Bertucci died, all of a sudden, despite assurances while he was living that Mr. Watkins had not taken more than $39,000 of compensation, equal to Mr. Bertucci's compensation, despite that, he presented a litigation spreadsheet in which he claimed compensation of $475,000. And that was spread not over 2 years, as the court indicated and my colleague argues, but over 14 years. 14 years of compensation claimed for management fees, bonuses, allowances of all types. And that, we maintain, was an attempt to disguise and mask defalcations that had been continuing over the years as Mr. Bertucci was providing funds to the venture. So the frequency of the meetings where Mr. Watkins suggests that he was providing full and fair information and that Mr. Bertucci was completely satisfied with it is actually countered by a reasonable inference that a juror might make that there was no fair disclosure. In addition, on the limitations issue, when Mr. Bertucci died, finally, in the course of discovery, we got a copy of a single spreadsheet which we have briefed, and we identified as Exhibit I in our briefing. We got a copy of a spreadsheet covering 7 years of their business transactions, and it only reflects $39,000 of compensation. It doesn't reflect any of the claims to the $475,000 over 14 years, or even 7 years. Bear in mind, those claims were in every single year except 2. So this is essentially more than a scintilla of evidence that that misinformation was being provided to Mr. Bertucci, which led him to believe incorrectly that his partner had integrity and was not defrauding him.
May I ask you, if we were to agree with you on your briefing waiver point, and those derivative claims could proceed, what would it add to also have a fiduciary duty claim as to the individual? Or as to, yeah, go ahead.
I think it is clear from Ritchie against Rupee and from the Wingate against Hodgett case that we are not entitled to an individual claim if there is a derivative claim that can provide relief for the companies. Where we think we do have an individual claim is because there was testimony by the auditor, Mr. McIntosh, who had looked at the books, and I haven't gotten into that issue yet, but who looked at the books and testified to 2 things of import. One was that that he had seen in the records that Mr. Watkins had withheld distributions from Mr. Bertucci, which he could not find evidence had been expended on project expenses. That was one thing. That would be an individual claim. The second is that he testified that there were monies coming in excess of $170,000 into this TCB account that Mr. Watkins had dominion over, and those monies the $170,000, he could not identify, and acknowledged that they may have come from the projects and that Mr. Bertucci might not have received his share. If both of those are correct, there would be an individual claim and damage in that instance.
Do you want to briefly address that auditor's report?
I would, thank you. The auditor's report, well, first let me start by saying, in the case of Simpson against Canales, this court stressed that the courts should employ Rule 172 only where necessary to further the rule's express purpose of justice, which is a manifest objective of the auditor rule, 172. That's the purpose. Under Rule 172, verification is a prerequisite of an audit report. It is not a trivial or empty formality.
So the Court of Appeals didn't get to this at all. One thing we could do would be to tell it to do so.
That is correct.
Should we do that if we agree that it was wrong to have not addressed it, or should we address it ourselves?
I think you could address it yourselves on this record. We have in the record a 552-page critique of that report. Obviously, not all of it is text, but much of it is record, substantiating our criticism of the report. The basic rule here is this. This is an unverified report. The contention that it was ever verified is simply false. After I took Mr. McIntosh's deposition, which was delayed incidentally because his wife was terminally ill, so we agreed to a continuance of 3 months. But after I took it, within 1 month, we filed our objections to his report. When those were filed, a month later, he withdrew his report, stating that it was erroneous and contained mistaken assumptions. He also conceded that he could not validate Mr. Watkins' compensation claims, and the reason he testified he could not validate Mr. Watkins' compensation claims in his deposition was because there was no document. And in fact, the compensation claim in that report, which he did validate in the report, but without any substance, he validated on the basis solely, and he admitted this, of Mr. Watkins' ipse dixit. Well, the one thing about an expert is that he should always have a basis in data, and particularly under a Rule 172 audit, he should have a basis in fact and data in order to be able to verify his report. So he withdrew his report, and then when it appeared that the court was going to enter a ruling admitting the report in violation of Rule of Evidence 706, he suddenly presented a verification. And the verification said this. It said, at one time in the past, I believed the report was true. And that came after he had renounced it as inaccurate and mistaken, and denied that he could, and disclaimed his ability to validate Mr. Watkins' claim to compensation. So if you take the importance of a verification as serving the purpose of justice under Rule 172, his sham verification, belated verification, did nothing to establish the probity of the report. Nothing whatsoever. So I think that on this record, you could rule based upon principles which have long applied to expert reports, that this report absolutely should not be admitted. Now that it has been admitted, here's the irony. The irony is that we prevailed in the Court of Appeals on our objections to the dead man's rule, based on the dead man's rule. We had raised numerous objections that the only thing that Mr. Watkins could present to support an oral agreement of the decedent was his own ipse dixit. So we objected to that. We were overruled in the trial court. We were sustained in the Court of Appeals. And so at this point, there's nothing to support this report because it relied extensively, as you'll see in our tab number 2, on the ipse dixit of Mr. Watkins.
Any other questions? Thank you, Mr. Fleckman.
Thank you, Your Honor.
We'll hear from the respondent.
May it please the court, Ms. Block will present argument for the respondent.
May it please the court. Good morning. I'm here with my co-counsel Timothy Zeiger. I'm also pleased to report that we have a number of our Greenberg Traurig associates attending today watching the arguments. And I certainly want to address the briefing waiver and the audit issues that the petitioner has raised, but with the court's indulgence, I would like to start with our 2 cross points because I do think they are dispositive of the entire appeal. And our points are, number 1, there was no fiduciary duty owed by Watkins individually to Anthony, and I'll refer to the decedent as Anthony, individually as a matter of law. And number 2, all of the executor's claims are barred by the statute of limitations, even if a fiduciary duty exists. Now, on the existence of a fiduciary duty between limited partners, we submit that the issue is governed by this court's fairly recent decision, if not governed, at least guided by this court's decision in re Estate of Poe.
But that involved a corporation.
It did. It involved a limited liability corporation, which in many ways is similar to a limited partnership. Not the same. They're distinct entities. But the reason folks organize a company as a limited liability company is to limit the exposure, limit the liability of the members or shareholders with respect to the LLC. In a limited partnership, it's the same theory.
To external people, third parties who might be
True.
suing, certainly. But even in an LLC, you can have, depending on the company agreement, you can have extensive fiduciary duties that are owed by the members to each other, right?
Exactly.
And the same is true of limited partnerships, right?
Yes.
And if it's silent, if the limited partnership agreement is silent, then doesn't the Act instruct us to look to the General Partnership Act?
To some extent,
And the general partnership, it says if it's silent regarding duties, the General Partnership Act governs.
well, it doesn't say if it's silent. It says, and I'm looking at 153.003, applicability of other laws, and it starts out, except as provided in subsection B, and then in some other instance, the provisions of Chapter 152, which govern general partnerships, the provisions of Chapter 152 governing partnerships that are not limited partnerships, and the rules of law and equity govern. So the statute is pulling in the existing laws of and equity that we already have in our jurisprudence. And then subsection B, again, subsection A says except with respect to as provided in subsection B. Subsection B says the powers and duties of a limited partner shall not be governed by the provisions of Chapter 152 that would be inconsistent with the nature and role of the limited partner as contemplated by this chapter. And then look at subsection C. A limited partner shall not have any obligation or duty of a general partner solely by reason of being a limited partner. So that's a recognition by the legislature when they enacted this statute that our existing body of law is that limited partners as a general rule do not owe each other fiduciary duties.
I think that's fine when a limited partner is acting in the role of a limited partner.
Exactly.
But what happens when the limited partner takes on management, operational roles that are acting as an agent on behalf of the partnership, more akin to
Right.
the role of a general partner or an agent of the business organization?
And that's spot on. That's exactly right. And that's the suggestion that was made in actually you were on the
Strebel.
panel, as was Justice Huddle, in the Strebel versus Wemberley case. And I'm going to back away a little bit from my criticism of that case because, for a number of reasons. First of all, the court, the Houston Court of Appeals at the time was struggling with a lot of conflicting authority on the issue. It did recognize the general rule that limited partners do not owe fiduciary duties to other limited partners when they stay in their lane, when they stay in their role. But it suggested that when a limited partner exercises control over the affairs of the limited partnership, that may impose duties. But here's the catch. It's not uncommon at all for a limited partner to have a limited partner role, limited partner hat, and also be an officer or director of a corporate general partner. And that's exactly the case we have here. And if you look at our oral argument exhibit B, what I've done there is at the bottom there are two excerpts from the limited partnership agreement in this case. And there was only one limited partnership of the 5 entities that are parties to the suit. And those are standard provisions. Management is with the general partner, and there is to be no limited partner control. And when you couple that with, at the top of the page, I've set forth section 153.103, and that's actions not constituting participation in business for liability purposes. And Justice Busby, you're right. The statute is talking about liability to third parties. But the same reasoning applies. Look what the statute says. A limited partner does not participate in the control of the business of the limited partnership when that limited partner has other roles to act in, has other capacities such as acting as an agent or employee or director of a corporate general partner. And that's exactly what we have here. I've included in the exhibits, Exhibit A is an organization chart or the entity chart. And that lists the 5 entities that are parties to the suit. The bottom one is the limited partnership. The general partner of that limited partnership was a corporate entity, American Affordable Homes and Properties, Inc. So we have exactly the situation that the statute is talking about. Anthony was the president of the general partner. My client, Watkins, was the vice president. So they both owe duties to the general partner who, in that capacity. But the key here is that when Watkins was exercising any control over the limited partnership, which was the critical part that the Austin Court of Appeals said might give rise to a fiduciary duty, relying on the Strebel case. When Watkins was exercising control, he didn't have his limited partner hat on. He had his vice president of the corporate general partner hat on.
But you would agree then the claim could be brought derivatively against him as an officer?
Oh, well, yes, officers owe fiduciary duties to their companies. Anthony owed the same duties that Watkins did.
So you're only cabining this in connection with an individual claim?
Exactly,
for
individual fiduciary duty. There is no individual fiduciary duty owed by Watkins as a limited partner to Anthony as a limited partner. And the fact that he exercised control doesn't matter, does not give rise to a fact issue that would defeat summary judgment because he was acting as appropriately. He was doing his job as the vice president of the general partner.
So how do we, I know you pointed us to the limited partnership agreement for that, but if there were a case where there was not, where the person who was the limited partner didn't have an officer role in the corporate general partner, and the evidence showed that they routinely flouted this provision, you would say there would be a fact issue.
I think there could be. That's not our case, but I think there could be. In the Macbeth, I think it's a Fifth Circuit decision that the Strebel Court relied on. I think came really close. They were saying that there was one person who acted in many roles, but it wasn't clear which role he was acting in, and he exerted control over everything. And I do think
Why isn't that the case here, that it's not clear which role he was acting in?
well, there's no allegation that he wasn't acting in his role as vice president of the general partner.
Is there any evidence that he was?
Yes, I mean, he was doing his job. He was.
Well, but is there any documentary evidence that he was?
Well, yes, in the sense that the limited partnership agreement recognizes that it's the general partner that will be exercising control.
Right, but other than that, that's all, the provision you pointed us to in your excerpts. There's no sort of operative documentary evidence of which hat he was wearing.
Well, I think there is, because you know, as Poe instructs, you look at the governing documents, and the governing document here says there is to be no limited partner control.
And so that's conclusive, you would say.
I submit that it is. There's certainly no evidence to the contrary.
If we concluded that there was no briefing waiver and that Bertucci should be permitted to pursue the derivative claims on behalf of the entity, what difference does it make whether Watkins owed a fiduciary duty to Bertucci individually in the outcome of where this case goes?
Well, you're asking, if I'm understanding it correctly, I think you're asking a very broad question. You know,
I mean, if we
who owns the cause of action?
If we agree with you and the Court of Appeals on the briefing waiver issue, so he's basically waived any derivative claims and he can only make claims on his own behalf, then it clearly becomes important whether he has a viable claim for breach of fiduciary duty to him personally.
Sure.
But if we disagree with you on that point, so that he can pursue claims for breach of fiduciary duty to the entity and pursue those on behalf of the entity, in terms of remedy, damages, relief, does it ultimately make any difference whether he can also pursue claims for breach of fiduciary duty to him individually? And if so, where does that matter?
Well, let me try to answer it this way. And I think what I keep wanting to come down to in listening to your question is the executor agrees with the dissent statement that the claims asserted by Anthony individually are the exact same claims seeking the exact same remedies as the derivative claims. I agree with that. They are the same claims, same allegations, but there's only one set of damages. And I certainly understand that, you know, pleading in the alternative, if you're not sure if it's an individual claim or a derivative claim, and we have lots of cases on that. But ultimately, the claim belongs to one or the other. They do not have distinct claims. The executor has made it very clear in his brief. And he's picked the horse he's going to ride on, and the horse he chose to ride on is alleged theft, alleged misappropriation of Anthony's money.
Well, couldn't it be both?
Go ahead.
Couldn't it be both? Couldn't it be misappropriation of limited partnership funds that were then to be distributed to Anthony under the limited partnership agreement?
Well, they never.
That it's misappropriation of both partnership funds and then, because of that, also funds that should have been distributed to him? Well,
I think the right answer is sure, it could be, if those were distinct claims. I mean, if we had evidence that Watkins misappropriated Anthony's money in X number of dollars and also misappropriated company money in a different number of dollars, sure, those two claims could go on together. Different damages. Different claims.
It's what I heard Mr. Fleckman to say a few minutes ago, was that there was a $175,000 amount, I thought, that was no longer in the possession of the entity that had been distributed, but actually not turned over.
Well, if you look
what do you have to say about that?
And I'm not remembering exactly what he said, and perhaps he can clarify it on rebuttal, but When you look at his briefing, and it's been consistent throughout the pleadings in the trial court, pleadings in the Court of Appeals, and the briefing in this court, the executor has made it very clear that his claim, both of his claims, individual and derivative, are really only one claim, and that is the alleged theft of Anthony's money, not the entity's money. And his theory is that Anthony was making deposits into Watkins' TCB account, over the course of 13 years, and that Watkins was paying for company expenses, application fees. I mean, they're all office supplies, copy machines, mileage, getting reimbursement for those kinds of things. One of the big things is that he complains about is a $50,000 goodwill bonus that we know was paid in 2008. Now this, I'm going back to this statute of limitations on this issue, but I mean, I think that's a clear example that it's Anthony's money as president and majority owner of all of these entities. He knew how much money he was putting in. He knew how much money was being spent on company business. That, again, that goes to the statute of limitations, but let me get back to your question. If you look at the top of, actually, I'm not sure it's on the top, on page 31 of the executor's response to our cross-petitioner's brief on the merits, he says, and I quote, "Executor's complaint is instead that Watkins cannot account for and has misapplied Anthony's funds." Again, on page 21 of their brief on the merits, he complains about this alleged compensation that Watkins took for himself. And he defines what he means by compensation. He says the compensation the executor is complaining about is, quote, "the monies Watkins is alleged to have diverted from Anthony's funds." And his whole theory is that...
So let me get clarification here.
Yep.
The first issue in this case that the petitioner presents is whether he waived any derivative claims by failing to adequately brief them. Are you also arguing that even if he didn't waive them, he's never asserted them because he's only ever claimed theft of his own funds?
Well, he asserted them in the trial court. But in the appellate courts, he has consistently, well, and actually it's been pretty consistent.
So
he
that's
asserted
part of
claims
your-
on behalf of both. But his theory has been consistently the same, that Watkins allegedly misappropriated money that Anthony deposited into the TCB account that never got to the companies. It never was spent on company, it never got to the company. It was never in a company bank account.
But it was company funds, whether it was in a company bank account or not, wouldn't you say?
Well, let's listen to what the executor
None of this
says.
is before us, so really what I think would be most helpful is to have an answer to Justice Boyd's question about if we say that there's no briefing waiver on the derivative claims, do we need to decide any of the rest of this?
Yes.
Why?
Well, yeah, you need to decide the statute of limitations claim and the existence of a fiduciary duty on the individual claim.
Okay.
Why?
Set aside statute of limitations and
Yep.
dead man's rule. I'm trying to figure out why, if we agree that he has not waived his derivative claims, we
Right.
agree with him that he's not waived it, why do we need to decide whether there's any validity to the breach of fiduciary duty to him as an individual claim? Why is that claim relevant if they're all seeking the same relief? Can he pursue the same dollars under the same theories under the derivative claim?
Well, ultimately the remedy would be different because if a company recovers money, that goes back to the company. My client was a 40%
So Mr.
owner
Watkins
of the
would
company.
get 40% of the damages he has to pay to the company? And damages he has to pay to the company for stealing from the company?
Theoretically, he would have to, pay a judgment to the companies, and then he would get 40% of that back.
Well, I assume his argument is, for his individual damages, is that there's something in the limited partnership agreement that would ensure the funds eventually went to him if they had been properly treated.
Well, he says, let me find this. Okay, on page, I think I mentioned this. I don't know if I talked about this reference on page 38 of the executor's response to our cross-petitioner's brief. He says, any portion of the $2 million that the companies did not need for expenses remained the property of Anthony. That's a quote. So his argument is the money that Anthony put into the TCB account, and again, these are his words, any portion of that $2 million that was not needed for expenses, for company expenses, remained the property of Anthony. Again, his entire theory has been that Watkins allegedly misappropriated Anthony's funds before they ever got to the companies, and if there was money that was misspent out of the TCB account, he claims that remains Anthony funds. So that does two things. Number one, and I'm out of time. Can I finish my thought? Thank you. It does two things. It's an affirmative confirmation by the executor that no money was allegedly taken from the entities. Instead, he alleges it was taken from Anthony, not the entities. But number two, it demonstrates that even if you find there was briefing waiver, it's harmless because the entities did not suffer any distinct harm, any harm or damages distinct from the damages alleged to have suffered by Anthony.
So, can I just,
Justice Lamb.
could you just briefly set out what you were going to say about your limitations argument?
Oh, boy. I've got lots to
Briefly.
say about that. Well, the two parts to the argument. Number one is, and I did talk about the existence of a fiduciary duty. We think there's no fiduciary duty individually as a matter of law. But even if there was, and then even with respect to a possible fraudulent concealment tolling of the limitations, I just ask you to look at our brief. We set forth a timeline. The critical thing there is Anthony knew or should have known. Whether you're talking about Anthony individually or Anthony as president of each of the companies, he knew or should have known where his money was being spent on his company's business. And if there was any discrepancy, and again, the $50,000 in 2008, how can he say he didn't know about that?
What if he was given Exhibit I?
I'm sorry?
What if he was given Exhibit I
What
that
is-
showed a different amount of compensation for Mr. Watkins?
I'm-
Should he have, your opposing counsel talked about Exhibit I, the spreadsheet that shows $39,000 in compensation to Mr. Watkins. If Mr. Bertucci received Exhibit I, why would he not have been entitled to rely on that? And what else do you contend would have led him to suspect that Exhibit I was not true?
And, well, I'm sorry, I'm not currently remembering what Exhibit I was, but the $39,000, I believe, is, for a while, they both took $6,500 out. And, you know, keep in mind, the big dollars are going to come in later when the developments are completed, but there are all kinds of ongoing expenses before that happens. And so both parties took $6,500 out on a monthly basis for a while, and then they stopped. But the point is, there are cost certifications for an audit, you know, looked at by the government for these low-income housing tax credits. In order to even qualify, you have to do the cost certifications. So that would show money that certainly legitimately was spent on any of the projects. Anthony knew those. As officer and director and majority owner, he had a personal interest too, but certainly as officer and director, he had a duty, a fiduciary duty to each of the companies to know whether the company was adequately funded, whether the monies invested into the companies was being properly spent. So he had a duty, he had an affirmative duty as officer and director of each company to know whether they were financially sound. He had an opportunity to look at the books and records and had a duty to do so.
Any other questions? Thank you, Ms. Block. Mr. Fleckman, you have 5 minutes.
Could you just briefly respond to that limitations argument?
Yes, I certainly can. I think that the discovery rule basically defers accrual until there is an event or circumstance that would give notice, inquiry notice to the plaintiff, to the claimant, that the bell has rung, and that reasonable diligence needs to be conducted. It really gets down to the Tri-X decision that this court decided last year. And the Tri-X decision was, until the lease default, Tri-X had no reason to question the fiduciary responsibility of Marcus and Millichamp. And that's the same thing here. These two men were friends. There was no hostility in their relationship whatsoever. They had gotten together well. They had done projects together. They were making money off of those projects. All of that would have allayed suspicion. Exhibit I shows that what Mr. Bertucci was shown did not give him the full disclosure that Willis against Maverick requires of a fiduciary.
If we conclude that Watkins had no fiduciary duty to Mr. Bertucci personally, if we disagree with you on that question, does your reliance on the discovery rule fail?
No, not at all.
In other words, does the reasonable, the should have known factor, the argument that he shouldn't have known, that you can't say he should have known, depend on the fact that he was relying so heavily on Watkins?
I'm not sure that I follow, and let me ask you if you wouldn't mind just clarifying, because I want to answer your question.
Well, your discovery rule your limitations defense is the discovery rule, which is under these facts, you can't say that he knew or should have known. And in part, I hear you saying because he was relying on Watkins
Absolutely.
to do what Watkins was supposed to be doing, but Watkins wasn't doing it. And their argument is, well, but he was still president of all these companies. He should have known what was happening with the money. And I think your argument is, well, but they were such good friends, he could rely on Watkins, which sounds to me like you're relying on the existence of a fiduciary duty to support your discovery rule defense.
Let me explain what my theory is. My theory is coincident with Boozer, which this court has recently decided. It doesn't matter whether the individual involved who has dominion of the monies of another person, it doesn't matter whether it's a municipal land title agent, as in Pippin, or whether it is someone who is an attorney like Mr. Holmes, who volunteered to be an escrow holder and then absconded with money. It doesn't matter whether it's a controlling partner in the business. It doesn't matter whether it's a transaction in which somebody has agreed to hold money. Once one is an agent and has taken an entrustment of money, they have 4 duties. They're special duties that an agent then has. One is complete disclosure. The second is a duty to account for that property. The third thing is the duty to conserve that property. And the fourth is a duty to distribute in accordance with his charge. And failing those fiduciary duties, he is liable to both parties depending upon who has been injured. So the question is not whether there's a fiduciary duty to Mr. Bertucci. There was clearly a fiduciary duty to Mr. Bertucci. The question for the jury is whether Mr. Bertucci can show a separate injury from that of the company, because if he cannot, then Ritchie against Rupee and Sneed against Fine teach us that there is no separate individual right. But if he can show that there was distributions were withheld from him and that monies came in from the projects that were not properly shared, then he has suffered a separate injury. There is one other possibility here, and that is this. These companies are now in liquidation. And so the only issue here is where the money goes that remains, or that is recovered from Mr. Watkins. So one way to look at this is if the companies did not receive the money, or alternatively, did not need the money that Mr. Watkins essentially embezzled, and then in that event, the money should be returned to Mr. Bertucci's estate and not held by Mr. Watkins. So any way you look at this, I think Mr. Bertucci has a separately articulable claim here. And what we've said is that the conduct is the same, but the injuries ultimately may be different.
Any other questions?
Would you also say, it seems like there may be a different argument, and I want to be sure if you're also advancing this argument, that even if Mr. Bertucci also owed a fiduciary duty to the corporations and the limited partnerships involved, would you say that he had a right to rely on the information provided by the operating partner, Mr. Watkins, as far as how that money was being spent?
Absolutely, and I'll explain why, Justice Busby. The fact of the matter is, we live in a society where we operate in the business field in teams. And the virtue of trust is as important and necessary as the virtue of being trustworthy. And that is why we rely upon people to whom we delegate responsibility. There is no way that I could practice law and spend my time auditing the books of my law partnership. And there are about 67,000 attorneys who practice in private firms in this state, and they would each have the same difficulty. One has to be able to delegate and place trust and know that it's not being betrayed.
Any other questions? Thank you, Mr. Fleckman.
Thank you.
The case is submitted, and the court will take another brief recess.